Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 12 in the list of AOR leading cases, which is Mafatlal Industries, etc., versus Union of India, etc. Okay, so this case is decided by a 9-judge bench, and it is basically related to Section 72. It is majorly related to Section 72 of the Indian Contract Act, which is providing you the doctrine of unjust enrichment. Okay, now what is happening in this case? So what is basically this case is, in this case, what is the moot question before the judges lies that if I have paid my custom duty by mistake of law, can I pay it? Can I get a refund of it? And what will be the position under doctrine of unjust enrichment? So this judgment is one of the landmark judgment when it comes to taxation jurisprudence, and it is basically talking of refund of indirect taxes and mainly focusing on doctrine of unjust enrichment. Now what is happening in this case is that the companies herein had paid, so many companies, because we are using etc., so companies herein had paid excise or custom duty. Okay, it was paid under a mistaken belief of law, and they were unconstitutional levies of excise or custom duties, and therefore they were seeking the refunds later on. Okay, now what was happening that there was writ petitions being filed under Article 226 for refund of such tax. Section 11B of the Central Excise Act was also being invoked, which is providing for the refund in case of the tax being paid. Okay, so now the question herein before the bench is that can a person who has paid indirect tax under a mistake of claim, so under when it is a mistake of claim, it automatically is becoming the mistake of law as well, right? So can a person who has paid indirect taxes in the form of custom or excise can claim refund without proving that burden of tax was not passed on to someone else? Now what is happening in this judgment is the just 7 out of 9 judges are, you know, declaring the majority verdict, and it has been held that constitution is competent to enact a provision which says that refund can be generated. Okay, doctrine of doctrine of unjust enrichment, which is provided under section 72 of the Indian Contract Act, it applies to tax refund, and a taxpayer cannot claim refund if the burden has already been passed to another. Now what is happening in this case that these companies have collected these excise tax and the duties, custom duties, from the customers they were dealing with. Okay, so when you have collected the tax from them and when you have deposited it, how would you get it back under the, under the law that, we have mistakenly, in a mistaken claim, we have paid the tax? So now the basically in this case, the court is also looking at doctrine of unjust enrichment, that you cannot be enriched just because, there is a provision that is guaranteeing you a refund. So court, the majority opinion is upholding the validity of section 11B, which is basically talking of that refund of duty can be claimed within the prescribed time, and it should be supported that the duty to pay those taxes were not forwarded to someone else, was not put on to someone else, because in this case it was being paid by the customers. The companies were dealing with in the form of indirect taxes. Okay, now court is also expounding upon the doctrine of unjust enrichment, in this case the principle of unjust enrichment, which is rooted basically in equity. Now when we study section 68 to section 72 of the Indian Contract Act, they are known as the quasi contracts, in which if you are getting some kind of benefit, the Contract Act imposes a condition on you to generate the, restitute the person who is giving you such benefit to the extent that you are being benefited. Okay, so principle of unjust enrichment is also rooted in equity. It prohibits a person from claiming the refund if the burden of paying that particular amount has already been passed to someone else in the form of indirect tax. So court herein is saying that even if the tax is unconstitutional, even if you are claiming something which you have paid under a mistake of law, even then we cannot grant you refund unless you prove that it was you who bore the burden of paying those taxes, because in this case the burden was shifted to the customers these company, these claimant were dealing with. So the court said that all the refund claim can be made even if there are unconstitutionally levied, the taxes are unconstitutionally levied, they can be made only under the provision which was section 11b of the customs act in this case, and therefore it cannot go beyond the measures of statutory mechanism. So the statutory mechanism herein is that you can be generated a refund if you succeed to prove that you were the one who bore the burden of the unconstitutionally levied taxes from you, or you have paid those taxes under the mistake of law as well. Okay, so the court also held that if you have a remedy under section 11b of the act, customs act, which we are discussing herein, if you have a remedy, then your particular remedy under article 226 and any civil suit jurisdiction shall also be barred, because you have a redressal mechanism under section 11b of the customs act, right? So now this case is we have just discussed that this case, yes, in excise act as well and in custom act as well. Okay, so both the acts, if we are having enough statutory mechanism, you don't need to file a writ as well as any civil suit beyond the framework as guaranteed to you under the provisions of custom act or excise act, which one in this discussion is section 11b. Okay, now refund can be claimed under the statutory provision. Okay, so refund can be made, but the only principle you have to adhere to is that there is no unjust enrichment, that you have bore the burden, so we will compensate you, we will refund you. But if you have shifted the burden to your customer and you haven't bore the burden, so how will we refund the tax to you? Which it means that we as authority, we are enriching you unjustly for something that has been paid by your customers. Okay, so now constitutional invalidity is not sufficient, however, by it is not sufficient for refund. So just because some kind of tax that was being levied comes out unconstitutional, or it is struck down, the tax policy is struck down, the payment of tax is not now a legal thing, not now a constitutional valid thing, even that is not sufficient to generate the refund. It must be proved within the statutory mechanism of relevant provisions of the customs act or excise act that there was no passage, no non-passing of the burden to bear the responsibility of tax to anyone else. Okay, so this was held in the case of Mafatlal Industries versus Union of India. Constitutional validity of section 11b of the Central Excise Act and related provisions with the Custom Act was upheld. Corresponding provisions were upheld because Customs Act and Excise Act both were having these kind of provisions of generating refund. Okay, and doctrine of unjust enrichment was being elaborated upon in this case, and then the scope of article 265 has also been applied in this case, that no tax shall be levied or collected except by authority of law. If there is a tax being collected except by authority of law, statutory mechanisms under the relevant acts can be invoked. For that, you cannot go to writ jurisdiction, you need not go to writ jurisdiction, or you need not file any separate civil suit, because you already have a remedy available under the statutory mechanism as provided by the Excise Act or as provided by the Customs Act. So now this case is overruling, okay, the writs that were decided in the case of Kanhaiya Lal Mukund Lal Saraf. The court herein is overruling those cases and therefore laying down the provision that when Article 265 bars taxation, it does not automatically entitle refund. For entitling refund, it should be proved within the provisions of the relevant act that there is the non-passage of burden to bear the responsibility of tax, which was not the case in this particular case, and therefore by 7:2 majority, this case has been decided, laying specific, very special emphasis on the doctrine of enrichment as elaborated and as illustrated in under section 72 of the Indian Contract Act, right? So this was mainly which was held in the case of Mafatlal. It is all there in the head notes of the judgment that has been provided to you on the Supreme Court of India's website. You can go to AOR's website and you can just scroll down and you will find all the head notes of all the cases that we have. You can also find the complete judgment. So now this judgment is running into 278 pages, and the entire judgment has been summed up in the video that we have just discussed. Okay, thank you everyone. Have a very nice day. Please stay tuned with us for more such cases. I hope your preparation is going well. I hope you all are doing well. Thank you everyone. Have a nice day.